Hi, I'm Colleen Kirby, a Maryland criminal defense attorney with the law firm of Price Benowitz. One of the issues I'm going to address with you today is a very common charge that I deal with, which is assault. Assault comes in two forms. There's first-degree assault and second-degree assault. First-degree assault is a felony and carries much more serious consequences than second-degree assault. The difference between first and second-degree assault is that first-degree assault is an assault involving a firearm or an assault in which the victim has sustained serious physical injury to their person. Second-degree assault is a misdemeanor, although should be taken very seriously. Second-degree assault can be what's commonly known as a battery, which is an unwanted touching in any way, shape, or form. It can also be when you place another person in reasonable fear of immediate bodily harm. For example, if someone holds up a baseball bat and threatens to hit the person with the baseball bat, that would be one example of an assault because you have placed that person in reasonable fear that they are going to be suffering immediate bodily harm at that time. With assault charges, one of the most common ways that we see them is in domestic violence cases. With domestic violence, the definition there does not necessarily mean that there's a romantic relationship. It's any relationship between the parties. And when I say any relationship, it could include boyfriend and girlfriend, it could include husband and wife, it could include ex-husband, any type of relationship there between the parties, that would be considered a domestic violence case. These are taken extraordinarily serious by the prosecutors in the state of Maryland. And in fact, they have specialized prosecutors who are trained in handling these domestic violence cases. As a former prosecutor, I have the insight and knowledge as to how to best assist you with getting the charges dropped, with mitigating your possible defenses, and preparing you for trial. With domestic violence cases, they can be charged in one of two ways. One of the ways they're charged is when the police arrive and the police file the charges. The other very common way that they're charged is when one of the aggrieved parties goes to the commissioner's office, files the charges, and submits them to the commissioner. The commissioner then issues either a warrant or a summons and sends the charges out to the defendant. At that point, the charges have been submitted to the state's attorney's office, and the prosecutor is the only person who has the discretion as to which way these charges are going to be handled. One of the most common misconceptions about domestic violence cases when they're charged through the commissioner's office is that when the person that files the charges changes their mind or makes up with the other party or doesn't want to proceed with it, they believe it's within their power to drop the charges. Unfortunately, that is not the case. Once it's in the prosecutor's hands, the only person that can drop those charges is the prosecutor. If you find yourself facing these charges, you're going to want to find an attorney who's not only experienced and skilled, but going to aggressively defend your rights. Therefore, it's extremely important that you contact an attorney immediately to protect your rights and protect you in court and give you the most zealous representation possible.